Yes, there's a step.
Sir, clarification na po dun sa...
John muna, kay John muna. Sino ba? Sino muna?
Ladies first.
Ladies first. Age before beauty. Beauty before age.
Sir, Stephanie yung Kiko from Solar News. Congressman Neil Tupas was saying that hindi po ni-release sa media yung 45 properties. But if we remember it right, meron po kaming footage na, or meron kaming video nun na sinasabi about the 45 properties. Can you clarify on that, sir?
Yeah, if you remember it right, it was at the House of Representatives where in fact a subpoena or request for subpoena was submitted by the prosecution. That was, I think, Friday or Thursday or Friday before the first trial date. We were in a hurry to have the subpoena issued already against the Chief Justice as well as the family, the wife and the children, para masubpoena na natin. And the reason for that was brought about by the letter coming from the Land Registration Authority, which identified 45 properties as being in the name or affiliated to the respondent. So, doon nangyari yun, no? If you remember it right. Siguro, let's not also get lost, Stephanie, no? Na parang all of those incidents actually took place even before the Senate made a strict rule in terms of disclosure. But if you'll recall, after we were after the Senate spokesperson talked to us, we made it clear already that we don't make any disclosures here unless the matter has already been discussed before the Senate Impeachment Court. And one thing needs to be made clear, which I think let's not get lost at the fact. Huwag tayong maliligaw na parang sinasabi 45 properties, 21 properties. So ibig ko sabihin, having 21 properties that have been acquired beyond your means is not a sin, but 45 is? Is it not a violation of your oath when in fact you are able to acquire a property which should have been for 24 million but you acquired for 14.5? Is it not a violation of your oath when you, despite having owned a property, 3 condominiums as early as 04, 05, and 09, you do not declare them under oath? Now, let's not get lost. I mean, it only takes one major infraction as far as being liable for perjury is concerned to establish a case of betrayal of public trust, which I think some of my colleagues also want to discuss. But you know, in terms of disclosures and the like, you have to also understand and accept that as far as when the instructions of the Senate was concerned, nung sinabi ng huwag kayo magdi-disclose ng kahit mga pleadings o ano, hindi na ho natin ginagawa yun. Pero that particular disclosure was a result of the subpoena that we filed with the impeachment court.
Sir, parang follow-up question lang. Hindi ba kayo mahihirapan kung sakasakaling talagang maging mahigpit ang Senate court sa lahat ng spokespersons included sa pagbibigay ng mga pahayag sa mga media, before and after?
Depende naman sa mga tanong ninyo yan eh. Kung ang mga tanong ninyo at alam ninyo na papasok sa merito, kami po ay magiging restraint, no? At maingat sa pagbibigay po ng informasyon. Kagaya ng sinabi lang po ni Congressman Miro, ang sabi nga po ang kailangan makita talaga dito, walang problema kung ang pagmay-may-ari ng lupa po ay dinideklara ng makatotohanan sa Statements of Assets and Liabilities and Net Worth. May problema kung hindi dinideklara ng makatotohanan sa SALN. So yun lang po, no? Yan ang nakalagay po sa Article 2 at yan dapat ang maging sukatan.
Dagdag ko rin po, dun may mga puntos kasi na napag-usapan dun sa floor, yung sa tinatanong ng ilang mga senador kung high crime ba yung ginawa ni Chief Justice Corona. Klaruhin ko lang po, may 6 po na grounds o basehan sa ilalim ng saligang batas At yan po ay ang treason, ang bribery, pagsusuhol, ang graft and corruption, culpable violation of the Constitution, other high crimes, at betrayal of public trust. Noong 1935 Constitution, 4 lang po yun. Noong 1973 Constitution, naging 5. Itong 1987 Constitution, 6 na po yung grounds. Ang pinakabago po, yung betrayal of public trust. Bakit po dinagdag yung betrayal of public trust? Kasi po, nung panahon ni Presidente Marcos, merong impeachment proceedings laban sa kanya. At ang depensa po ng mga miyembro ng Batasang Pambansa, sinasabi nila, hindi naman krimen yung ginawa nila eh. Kaya nga dinagdag ng mga Constitutional Commissioner members yun noong 1986. Ang definition po nila ng betrayal of public trust, it must not be, hindi naman siya kailangan maging krimen eh. Basta siya ay paglabag dun sa pagsusumpa ng isang public official. So yun po ang mahalaga, huwag natin kalimutan yan, huwag tayong malihis dun sa debate sa other high crimes. Sapagkat tatlo po yung final naming basehan sa impeachment o sa reklamo. At yan po ay culpable violation of the Constitution, graft and corruption, at betrayal of the public trust. Pinakamahalaga po dyan, yung pagtaksil o pagkanulo sa tiwala ng publiko, yung betrayal of public trust. Kasi nga malawak po yan, kaya nga yan po ang intensyon ng ating may akda ng ating saligang batas na talagang panagutin po ang mga makasalanang mga opisyal.
Yeah, Christine Herrera of Manila Standard. This is to also put the record straight because I think that the media cannot defend themselves before the impeachment court. Now, on the first day of the trial, I specifically asked you because the Chief Justice denied one by one the accusations leveled against him by the prosecution, like this property is not his, this is not his wife's, or that others came from inheritance. And I ask you if you still maintain and insist on the Chief Justice having the 45 properties, and you said yes. Now you're telling us you're changing your mind or your figures because you said it's not with the figures. The figure is nothing. So what is it then?
Yeah, siguro Christine, we need to be able to backtrack, no? Because I think from the very first day, if you will review, and well, this is just a product of recollection at this point in time, is that we were pretty certain that precisely we wanted the Chief Justice to be present, much like how impeached officers in other jurisdictions are made to be present in court so they can deny it firsthand. Meaning just like how President Clinton showed up at his own impeachment, the president of the most powerful democracy in the world. So we were hoping that he could make those denials not before the steps of the Supreme Court, but here, where it actually matters. In that area, in the same breath that we felt like it would have been better and even best for him if we could get it firsthand. Now, the discussion there, if I remember your question, was, do you stand by the information that you have that there are properties that they did not declare in his SALN repeatedly? And we said we stand firm that as far as we are concerned, there are properties that
I was very clear
even,
on the 45 properties. And
well, we will have to make that reckoning insofar as that recollection, but that is not my recollection. But I truly trust, I mean, if that is your recollection, but be that as it may, like as we said, we were very specific when we said that the violation for which the Chief Justice is being accused for, Christine, is the fact that there are properties that we have found out that he did not declare. And you see it already insofar as what the defense is trying to do over the last 3 days is established for the first time. Now that the SALN, the first line of defense is to say that let's not bring out the SALN so that we don't have to explain anything. Now when the SALN finally came out, they said it's okay that we just nakita na bakante or maraming properties doon na acquired na as early as 04, hindi dineclare. Okay lang yan, ipaliwanag na lang natin, there's a provision in the law that speaks about good faith.
So those 21 that Niel said, 21 properties he said. So those were not declared, those 21?
The 24, a great bulk of them were not declared when they were supposed to be declared.
24 of 24.
Yes.
All of
No, many of them, if I'm not mistaken, 18 of them were just belatedly declared come 2010. But when they were supposed to be declared, they were not. And in fact, they were, even if they were declared, they were grossly under-declared.
So 18 of 24. Okay, thank you.
This is Amy for ICTV and NowPlanet. I just want to ask, can you please draw the line regarding SAL-N corrections? Kasi they're saying that as long as it was declared, pero it was, subsequently declared a year later, it can still be corrected. Can you please draw the line regarding that?
Well, there was a case. Again, it's subject to a legal memorandum that the Senate is asking. The Plato case where even Plato used it as a line of defense in order not to be punished. No? That there is a provision that says that you can still correct your statements of assets and liabilities and net worth. But that was denied by the Supreme Court because according to them, this is an act of perjury. You are swearing under oath that what you've stated is true to your knowledge, and because of that, there's no room for correction. I'd like also to add, there's another case dated 2008. This is Commissioner of Internal Revenue versus Pelino, where it states that dishonesty is classified as a grave offense, the penalty of which is dismissal from service at the first infraction. So kung sa mas mababang level, dishonesty na, ay pwedeng ma-dismiss ang isang tao. Paano pa yung pinakamataas na maestrado ng Korte Suprema na nanumpa na kung saan itong statements of assets and liabilities and net worth ay makatotohanan?
Siguro dagdagan ko na rin, kasi yun yung 3 points of retreat na ginagawa ng defense ngayon. First line of retreat was to finally surrender the SAL-N. Nung lumabas na po yun, they were now forced to defend the document because it completely revealed the inaccuracies as well as the untruthfulness on the entries there. The second line of defense now is to say that it's substantial compliance. Yesterday they said na kapag nilagay ay zonal valuation, assessed value ng local assessor, okay lang naman yan, tanggap din yan eh. So nakita nila na kahit pa nandun, there was still a very glaring omission done for over 7 years by the Chief Justice. Hindi niya nilalagay yung acquisition cost up to today. So ngayon, ang sinasabi is, nung naipakita natin that the Chief Justice for 6 years had failed to declare his assets, particularly the 2 condominiums, as part of his SAL-N, biglang they're now shifting towards good faith, which is a provision na nandun din sa